So friends, Representative Scott "Pardon Me" Perry is trying to keep hidden from the grand jury the contents of his cell phone. But the good news is Chief Judge Beryl Howell is having none of it. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, we just got a look at a 50-page ruling that was released by Chief Judge Beryl Howell. Judge Howell is the judge in federal court in D.C. who has supervisory responsibility over the grand jury that is investigating the crimes of Donald Trump. And in that 50-page ruling, she rejected a claim by Congressman Scott "Pardon Me" Perry. I call him that because he asked for a pardon for the crimes he committed on and around January 6th. And Scott "Pardon Me" Perry said, even though the federal prosecutors got a search warrant for my cell phone because a judge concluded there was probable cause that evidence of crime was located in my cell phone, even though they got that warrant and took my phone, I don't want them to look at what's in there because it's all covered by something called speech or debate clause privilege. The only thing in there is just me, robustly discussing and debating legislation. Yeah, sure, Scott. And so I want to try to explain what happened and what we learned in Chief Judge Beryl Howell's ruling, but it's a little bit down in the weeds of criminal law and criminal procedure. So I'm going to do my best to kind of unravel it and clarify it, and you'll let me know maybe in the comments to this video whether I succeeded or failed, whether I made it clearer, more clear, or less clear, but I'm going to give it a shot. I want to start with the new reporting about this 50-page ruling that was just released, just unsealed by Chief Judge Beryl Howell. This is from the Washington Post. Headline: Fight over Representative Perry's phone has prevented review of 2,200 documents in January 6 probe. And that article begins, a secret legal fight over the cell phone of Representative Scott "Pardon Me" Perry, that's my editorial addition there, has prevented the Justice Department for more than 6 months from reviewing more than 2,200 documents, meaning text messages and emails, the kind of stuff found in our phones, has prevented DOJ for more than 6 months from reviewing more than 2,200 documents in the criminal investigation of former President Donald Trump and supporters' efforts to overturn the 2020 presidential election, a federal judge disclosed Friday evening. Chief Judge Beryl Howell of the U.S. District Court in D.C. released a number of previously sealed opinions after finding that the powerful public interest outweighed the need for secrecy in the constitutional battle over Perry's claims and the historic investigation. The Pennsylvania Republican has asserted that 2,219 documents contained on his phone are shielded by the Constitution's speech or debate clause, which grants members of Congress immunity from criminal investigation in their official capacities. But in a ruling in December, Howell rejected that claim for more than 90% of the records, ordering Perry to turn over 2,055 text messages, emails, and attachments after concluding that they were only incidentally related to his status as a lawmaker and not central to that status and constitutionally protected as part of his lawmaking. Okay, friends, so what does all that mean? Well, we have to go back to the beginning and connect some dots. First, and perhaps most importantly, a federal judge concluded that there was evidence of crime on Scott Perry's cell phone, and therefore that federal judge, a federal magistrate judge in Pennsylvania, having found probable cause that Scott Perry had evidence of crime on his phone, issued a search warrant. And Scott Perry's phone was seized. But because federal prosecutors know that some of the stuff on a congressman's phone or a congresswoman's phone might have some privileges, some speech or debate clause privilege, because maybe he's just using that phone to, robustly debate federal legislation. And so prosecutors didn't look at the phone. What they did was they gave Representative Scott Perry an opportunity to file a motion with the court, Chief Judge Beryl Howell, and tell the court whether anything on his phone is covered by speech or debate clause privilege, which would mean the prosecutors don't get to look at it. So Scott Perry took the prosecutors up on that offer, and he filed a motion with Chief Judge Beryl Howell. We're just learning all of this now because Judge Howell decided to release her ruling, and she disclosed all of this. So here is what Perry said. He said, "Judge, there are 2,219 communications on my phone, emails, text messages, attachments, that are privileged, speech or debate clause, all part of my official legislative duties, and the prosecutors can't see them, don't get to see them. Please don't release them to the prosecutors." And here's the really interesting part. We gave all of the contents of, I lapse into the royal we because I was a prosecutor for 30 years. I'm no longer a prosecutor, so they, pardon Perry. So the prosecutors gave the phone to Chief Judge Howell, said, "We haven't looked at it, we won't look at it, we have safeguards in place to make sure we don't violate any privileges that a member of Congress might have. So Judge, you go ahead and look at the 2,219 emails and text messages that Perry is claiming are privileged, speech or debate clause privilege, and we're not permitted to look at them. And please resolve that issue for yourself and let us know what you conclude." Here's the thing. Usually when we litigate issues before a judge, both sides, both parties, the prosecution and the defense, know the entire universe of the facts that we're dealing with. But in this circumstance, the prosecutors didn't even get to look at the phone because of those safeguards they had in place, just gave the information to the judge and let the judge make the decision. So the prosecutors didn't even get to weigh in on, for example, "You know what, Judge, we've reviewed these 2,219 messages on Scott Perry's phone. They have nothing to do with speech or debate, and they enjoy no privilege." The prosecutors didn't even get to do that because they didn't get to look at them first. So they delivered them to Judge Beryl Howell. Scott Perry made all of his arguments about why they were privileged and the prosecutors can't look at them. And here is what we learned when Judge Howell released her opinion. Without the prosecutors even making arguments, right? Even weighing in on whether there's any privilege attaching to these 2,200 emails, Judge Beryl Howell said to Scott Perry in substance, "Yeah, you claim that those 2,219 emails enjoy some kind of speech or debate privilege. BS." I'm paraphrasing. That's not exactly what Chief Judge Beryl Howell said. But she ruled that, yeah, you know what? Of the 2,219 communications that you, Perry, claim are privileged, 2,055 of them are not. And only 160-something of them are. What does that tell you? It tells you Scott Perry is full of you-know-what, trying to claim that 2,000 of his communications are privileged. Please don't let the prosecutors see them. And the judge, on her own, prosecutors didn't even get to make an argument because they didn't see the contents of those communications. On her own, she said, yeah, Congressman Perry, BS. 2,055 of them are not privileged. Now, is that any surprise? Scott Pardon Me Perry, the member of Congress who had to ask for a pardon because he knew he committed crimes on and around January 6th, and he wanted to get away with those crimes. Is it any surprise that those 2,000 plus messages that he claimed were privileged, just part of his legislative duties, didn't involve a robust debate on legislation at all? They involve something much darker. We don't know how dark. We don't know what those communications will reveal, but you can bet it's all about the insurrection, right? Remember, Representative Perry was also the one who would regularly visit Mark Meadows, and Mark Meadows would burn documents in his fireplace, in his office, when Scott Perry left. Nothing fishy about that. So here's the status of where things are now. Scott Perry has appealed, and the case is now up at the D.C. Federal Circuit Court of Appeals to see whether Judge Howell's order finding no privilege for 2,055 communications, they're all relevant to the criminal investigation of Donald Trump, and they should go over because they're not privileged, whether that opinion will be affirmed on appeal or whether it will be reversed on appeal. It will ultimately, in my opinion, be affirmed, if not by the three-judge panel, then by the full court sitting en banc, all appellate court judges. And then, of course, Scott Perry can appeal it to the Supreme Court, and he will likely lose. So yes, Scott Perry has once again weaponized the delay in the court system to his advantage, trying to run out the clock, trying to do a solid for his criminal associate, Donald Trump, and we'll see if he succeeds, or we'll see if maybe justice is done in a timely manner. Because justice matters. Friends, I hope that clarified rather than confused, but this is a somewhat dense kind of legal and procedural issue and posture that, the Scott Pardon Me Perry criminal cell phone issue is currently in. So let me know, please, in the comments whether you found that helpful or confusing. And as always, please stay safe, please stay tuned, and I look forward to talking with you all again soon.